Thank you so much, Sergey, for that very kind introduction, a very generous introduction. I don't feel I'm the founding father of TWAIL. That has been a collective effort, and I'll explain why in various ways. Let me just again thank all of you in Kazakhstan for this wonderful conference and for making all these superb arrangements. And we feel, I think, very privileged to have been at these universities and have had the chance to interact not only with old colleagues, but with new colleagues. So thank you for all that. Perhaps then I will begin. I feel I give the same talk over and over again. So if you've heard, if you watch one of my YouTubes, it's the same thing. But anyway, let me try and adjust or adapt a few things. First slide, please, Sergey. History has been the theme in many respects of this conference because it is in the title itself. This is a topic on interest or an approach that is one that I find very useful. And so my approach is going to be historical. And when trying to think about this topic, which is rather ambitious, I suppose, Asia and international law, past, present, and future, I was wondering what unifying theme might be. And as I took off from Doha, the #1 airport in the world, or so it is said, although I come from Singapore, so I'm not quite sure whether I fully accept that judgment, but it is a beautiful airport. And I was flying over, well, the territory beneath. And I was trying to think about the history of the territory that I was flying over. And this provides us with a map. And I like this map because it's not a European map. I'm not quite sure. Some of you might be able to identify the language or perhaps even work out the locations. But as I was flying over from Doha, I realized that I was flying over an area that had been once the Empire of Cyrus. That I was flying over a territory that, as I was passing over these beautiful mountains, I thought perhaps it's possible that Alexander's campaigns were fought in those mountains because he came into this area as well. And then, of course, we can think of all the succeeding empires that have occupied this territory. And here in Kazakhstan, it is very strategically located between two great empires, Russia and China. So if we look at, if I can go to the next slide, it occurred to me also that this has been the foundation, Kazakhstan has been the foundation of its own empire in many respects, the Golden Horde, which is an empire which was among the largest territorial empires the world has ever seen. And so then, of course, I thought, well, the theme is empire. And the theme is empire, past, present, and future. And one could focus on many other maps at different times of history, but all these entities have really aspired to be empires. And so much of the history and the politics of the region consists of rival empires fighting among themselves for domination. Because perhaps one of the defining features of an empire is that it can never stand still. It has to expand to survive, as it were. Or that is the mindset of empire. So with those thoughts in mind, then let me switch to a more recent empire. These are very ancient empires, if you think of Cyrus going all the way back then. But our discipline, the discipline of international law, owes so much to a different empire, an empire that arrived on the scene in Asia. And actually, come to think of it, in Central Asia, it would have arrived many years earlier. So, that itself is an interesting topic. But our next slide will perhaps focus on an empire that began in Latin America, but whose doctrines played an important role in the European entry into Asia and became a justification for the European conquest of Asia and many other territories. And so, if we are concerned about empire, the question, of course, that we face as international lawyers is, how does international law relate to empire? And it does seem to be the case that international law has been used as an instrument of empire, and the Western tradition of international law certainly has been developed in the context of imperial expansion of European countries. And so we might think of empire as having two dimensions. One is an economic dimension, and other is a military dimension. So in other words, the two great themes of empire, and there are many great themes, but at least two would be trade, that is economics on one hand, and war and conquest on the other. So if we think about trade, I'd like to cite this principle from somebody who might be regarded as perhaps the first Western scholar of international law. His name was Francisco Vitoria. He's a scholar that I've been engaging in for many years because he is so fascinating, and I continue to learn from him. And his argument was, it was permissible from the beginning of the world when everything was in common. Very interesting idea. Everything is in common. The whole world belongs to everybody. For anyone to set forth and travel wheresoever he would. It is certain that the Aborigines can no more keep off the Spaniards from trade than Christians can keep off other Christians. So here we have a very interesting principle, which is that everybody has a right to travel, and that is linked to economics. The right to travel is linked to trade. And that is such a fundamental right, something like a jus cogens. I don't think it appears in the ILC draft, but the right to trade is so fundamental that every society has to permit it. Now, this was very convenient, of course, at a time of European expansion, because what it meant was that Europeans could enter the lands of all these foreign peoples, and they would have legal justification for doing so. So that was, you could say, one of the fundamental principles of trade. And next slide, please. And this is Francisco Vitoria, the great scholar. I admire him enormously, actually, for many reasons, even though I'm critical of many of his writings. And he wrote in the 1530s. And as I said, his lectures on the Indians and on making war on the Indians are regarded as perhaps the first modern text of Western international law. And I use the word Western international law because there are many other international laws. And here we look at the issue of trade. And we look at all the trade networks that were set up by a European empire, supported by the writings of Vitoria. And these are the trade networks that have been established by the Dutch East India Company. And I would claim that the Dutch East India Company, in many respects, is the founder of globalization because it connected the world in all these different ways. If we have a look at that map, we can see virtually all the continents. Australia might be excluded for the moment, but all the continents connected with each other through these trade routes. And the Dutch East India Company was a corporation. It wasn't a sovereign state. And it was an extraordinary entity. And it acted pretty much as a sovereign. And it had a huge advantage when it came to actually its operations. The huge advantage it had was that its in-house lawyer was the scholar that we know as Hugo Grotius. And so long before he wrote his great work, The Rights of War and Peace, the work that is known in Europe and for which he is famous, he wrote a small book called The Free Sea. And that book was written, that pamphlet really, was written to justify the trading of the East India Corporation in the region around Singapore and what is now Singapore, Malaysia, and Indonesia. Next slide, please. And Grotius drew upon the writings of Vitoria in that respect, because Grotius also said there is a fundamental right to trade, and every state has to respect this right. And if a state fails to respect this right, then of course it is in violation of the law. And if it is in violation of the law, then it is appropriate to impose sanctions against that non-European entity. And of course, the ultimate sanction is war. And so we can see the intimate relationship between trade and war. And we can see the way in which entering foreign lands, also claiming that those foreign lands are occupied by people who do not own the territory as such. The other argument was within these lands there are resources inside the earth, and If the natives have not themselves appropriated those resources, then those resources are available to whoever enters those lands. So can we see the issue of how European expansion could be justified in all these ways? So this is the Dutch East India Company. It is its, I guess, coat of arms, because it was pretty much a sovereign. Next slide, please. And this is Grotius, the older Grotius. It was the young Grotius who wrote The Free Sea and also the commentary of the Law on Price and Booty. Next slide, please. So now let me turn to the question of war, having mentioned the question of trade. Almost from the beginning of international law in its Western form, a distinction was made between wars conducted between European states and wars conducted between European states and non-European entities. And of course, Asia consisted of non-European entities. And the basic idea was, and the basic concerns and issues and themes were raised by Vittoria. So he raises the question, first, in the just war, one may do everything necessary for the defense of the public good. So here's an interesting idea. Are there any limits to self-defense at all? That is the question we have to consider. And it was raised right at the beginning of the Western tradition of international law in the context of a war made against non-European people. And note the term just war. What is a just war? And if we look at the issue of trade, can we see how the argument would be, if you resist us when we come into your territory, that is a reason for just war. Can we see that? It is you who are the aggressor by preventing us from coming into your lands and appropriating your resources. That is a just war. And once a just war begins, there's a question of, well, are there any limits, or do you actually fight the war until its very conclusion? Then we can see the further distinction, the pagan. In other words, the pagan in this context would have been an Islamic entity. And here he says, hence our war against the pagans is of this kind, being permanent. It is a permanent war, because they can never sufficiently pay for the injuries and loss inflicted. It is not to be doubted that we may lawfully enslave the women and children of the Saracens. So the Saracens, again, we should think of all this in the context of the Crusades and so forth. And normally, Vittoria does go on to say, women and children are normally protected, but in the case of the pagans, they are not. They can be enslaved. And then we have his further extension of a justification for conquest, which is sometimes security cannot be obtained without the wholesale destruction of the enemy. This is particularly the case in wars against the infidel, from whom peace can never be hoped for on any terms. Therefore, the only remedy is to eliminate all of them who are capable of bearing arms against us, given they are already guilty. They are already guilty. And what this also meant was that children could be seen as capable of bearing arms, and therefore could be subject to war and violence. Having said that, I also find Vittoria a very complex writer, because he also says it is never right to commit evil, even to avoid greater evils. So we can see an interesting set of ideas that arguably have been profoundly important in shaping the laws of war. But we should also understand that this is a particular type of war. It is what I would call a colonial war. It is a war against non-European peoples. Next slide, please. So then we go to the story of colonial wars in more modern times. And this is an American scholar writing in 1927. It is published in the American Journal of International Law. It is published in response to an article published by the very famous American jurist Quincy Wright. And it had to do, once again, about a war conducted by a European entity on the people of the Middle East. It was the French bombing Damascus. And Quincy Wright argued, well, you have to adhere to the laws of war, even in a war against these people of the Middle East. And Eldridge Colby said, no, we can't do that because it's a different type of war. It is a different type of people. And here we get a glimpse of what he says. When combatants and non-combatants are practically identical among a people, and savage or semi-savage peoples take advantage of this identity to effect ruses, surprises, and massacres on the regular army, commanders must attack their problems in entirely different ways from those in which they proceed against Western peoples. When a war is between regular troops and what are termed irregular troops, the mind must approach differently. All matters of strategy and tactics are necessarily also matters of the rules of war. In other words, fighting against non-European peoples, these people are guerrillas. There is no distinction. In effect, the category of civilian does not exist in this type of a war. So they are all seen as potentially enemies. The women and children also participate in the war. And even if they don't participate in the war, the guerrillas themselves make use of this status to actually embed themselves and so forth among these people, as a result of which they are appropriate military objectives. So this is the essence of colonial war. And we can see this theme starting from 1530 and going through till 1927. And a further thing which Colby emphasizes is that war against non-European peoples has to be war which is exemplary. It must not only achieve military objectives, it must set an example. It must terrify them. It must give them a sense that they are being punished by God himself. And so this adds a special dimension of cruelty to the type of war that would actually be waged against non-European peoples. And that was seen as essential for the type of war that was to be waged in these circumstances. Now, those of us who have studied international humanitarian law, and I am not one of those people, I rely on Rustam and others to inform me better, are relieved to think that this is the law of the past. These things do not happen anymore because we have a new set of principles, a different regulation, the Geneva Protocols, the additional protocol, the ICC, all that would make these types of practices illegal and condemnable. Okay, so I've covered some of the basic fundamentals of imperialism in terms of economy and war. There's a huge amount to be said more about economy, but I'll postpone that for the moment. Next slide, please. Here's another type of war against a non-European people. And I think all of you would be familiar. After all, surely all of you have seen Oppenheimer. No, Oppenheimer didn't show the bomb. Did he show the bomb? I can't remember. No, it didn't. All right, sorry. So then this is what Oppenheimer left out, the actual bomb. On the 6th of August. So this was a war against a non-European people, and Japan, after all, had attacked the United States. And for the first time in history, humankind became aware of the fact that it was possible to destroy the entire world in this context of a war, and it is a war against the non-European people. It would have been interesting to think about whether a bomb might have been dropped against a European enemy. That's an issue that scholars have debated in various ways. But the argument is, well, this ended the war once and for all. Now, this was the 6th of August, 1945. Next slide, please. And we can see what Oppenheimer did not present on screen. The impact of this war on all the people who lived in Hiroshima. And of course, we know the extraordinary suffering that they experienced and the long-term suffering that they experienced. Next. The interesting thing is that the London Charter was created on the 8th of August. 2 days after demonstrating that humanity could be completely destroyed in a war, we have the London Charter, which is the foundation of modern international criminal law. Is that right? Would we say that? And the London Charter says, crimes against the peace, planning, preparation, initiation of war, or war of aggression, next. And most importantly, war crimes, violation of the laws or customs of war. Such violations shall include murder, ill treatment, deportation to slave labor, etc. And also for the first time, this notion of crimes against humanity. So it's very interesting that humanity is protected at 2 days after we have this circumstance where humanity is in a way destroyed, at least in terms of Hiroshima, and the larger suggestion is this could destroy the world itself. Crimes against humanity, murder, extermination, enslavement of any civilian population before, during the war, whether or not in violation of the domestic law of the country, were perpetrated. And so the civilian population here is recognized, but what does that mean in the context of an atom bomb? Next slide. Well, 9th of August, we have another atom bomb. So the positioning of the London Charter is really interesting as it takes place. International criminal law is born in between the two atom bombs. What does this mean? How should we think about it? Is it the case that we need to have a devastating war and then create a system of rules? Or is it the case that we create a system of law thinking it would never be applied to us? And here again we come to the issue of race. Now the interesting thing is that the United States signed the UN Charter on the 8th of August, in between the two bombs. Now of course the UN Charter did not come into existence or did not become binding until later. But this conjunction of events raises all sorts of interesting events and themes. Okay, next slide. Okay, Asia. So all this is taking place in Asia. The atom bomb was dropped in Asia. And of course, we have war crimes tribunals, and we have Justice Pell saying this is Victor's justice. As somebody said, he might be considered to be the first Twale scholar in many respects for making this claim. Now, the first attempt of Asian peoples to meet as a community to express their views of the international system and the global order took place in 1947. And this was the Asian Relations Conference, which took place in New Delhi. And it's interesting to note that there were 2 delegates from Kazakhstan at this conference. How is that? Because at this stage, it wasn't a conference of independent states. This is 1947. There are not many Asian independent states. So it was more the case that these were the leaders of these different Asian countries. So Kazakhstan was there. And Gandhi gave a great speech. And in his speech, it is on YouTube. In his speech, he talked about the atom bomb. That became the defining event for those people. And you might even think of the Mahabharata, a weapon that could destroy the whole world. It has become a reality. In fact, I think that's picked up in Oppenheimer, isn't it? I have become death, the destroyer of worlds. Okay, our next moment is Bandung. And I'd like us to think about the past, present, and future in terms of the efforts made by the people of Bandung, the delegates at Bandung, to articulate a vision of international law and global order that corresponded with the wishes, the interests, the concerns of Asian people. And not just Asian people, and this is something I would like to emphasize. The leaders at Bandung, and they included Nehru and Sukarno, and Sri Lanka, actually. Sri Lanka was involved in this as well. They realized that they had a great deal in common with the Africans. And so this was made not just an Asian conference, but an Asian-African conference. And that is what we tried to reproduce a year ago in Bandung, and many of you were there. And it was a very special occasion because we actually visited the hall in which this took place. We stayed in the hotel in which the delegates actually resided when they went to the Bandung conference. And as our president at that time, Professor Hikmahanto Juwana said, when you were in your hotel room, did you think who was here in 1955 in this very hotel room attending the Bandung conference in 1955? So what were some of the major themes of Bandung? Next. So I would say, just listing these quickly, nuclear war and disarmament. Understandably, because of the extraordinarily traumatic impact of what happened in Hiroshima and Nagasaki. The next theme was economic development, of course, understandable concern. There would be a whole presentation on that. We don't have time. self-determination and anti-colonialism. That was the uniting theme, because the question is often asked, what is it that unites Asian peoples, Asian states, and Asian societies in a situation where there are so many differences among these societies? Well, I would say it is the theme of empire and imperialism. And that is also what unites Asia with the peoples of Africa and Latin America. It is this common experience of having been subjected to imperialism and trying to devise a way of formulating anti-colonial ideas and initiatives to end this whole process. Now, the important and interesting thing is that they focused a lot on racism. But I want to emphasize here that they focused a lot on racism, and I will read here the particular provision. It says, the African Asian Conference deplored the policies and practices of racial segregation and discrimination, which forms the basis of government and human relations in large regions of Africa and in other parts of the world. Such conduct is not only a gross violation of human rights, but also a denial of the dignity of man. So here they could see the beginnings of apartheid, and they wanted to resist that, but also there's a long colonial history of racism that they were also negating in various ways. But the interesting thing is that they also reaffirmed the determination of Asian African peoples to eradicate every trace of racialism that might exist in their own countries. So it's important to note that Bandung articulated a set of ideas which applied not only to the external world, but to the internal world. In other words, they said we have to be aware of racism within our own countries. And here I am afraid to say that many Asian countries have failed to abide by that principle, because racism is rampant in many Asian countries. We were discussing this in terms of Sri Lanka, the racism in Sri Lanka, the civil war that took place there. And I think we can see what is happening in Myanmar. Racism has been a feature of the governance systems of many countries because of racial politics, nationalist politics infiltrating the system. And people win votes by being more racist. Okay, the next theme would be dissatisfaction with the governance system. The Bandung states felt excluded from the United Nations. They weren't involved very much in the formulation of the United Nations system. And a war was taking place in Vietnam, as a matter of fact. And despite the fact that the war was taking place in Asia, there was no engagement by Asian countries in the processes of resolving the problems of that war. So there was dissatisfaction with the system of international governance. And then there was also the interesting idea that actually we are the majority. In other words, if we put together Asia and Africa, the population of Asia and Africa is larger than the rest of the world's population. So there is this paradox of speaking for the world in this sense, representing the vast majority of the peoples of the world, and yet being excluded from power. Can we see the issue? And perhaps that continues to be the case. So we can see how these themes, I could follow each of these themes to the present. But let's go through this quickly. And then one more theme. One more theme earlier. The further theme of Bandung was, it said, we are against great power politics of any sort. Now, this was taking place in the context of the Cold War, the Soviet Union and the United States, and the Bandung state said, we are against a system governed by great powers, wherever they come from. So can we see there's a different type of ethos here? We represent the peoples of the world. We do not want a world dominated by great powers of any kind, wherever they come from. Because great powers, it would seem, is yet another word for imperial powers. You can't be a great power without being an imperial power. I would present that as a rather stark argument. And perhaps we can argue about that later. There's one other concern at Bandung. In view of the existing tensions in the Middle East, caused by the situation in Palestine, and of the dangers of that tension to world peace, the Asian African Conference declared its support for the Arab people of Palestine and called for the implementation of the United Nations resolutions on Palestine and the achievement of the peaceful settlement of the Palestine question. Those words are haunting because they could actually apply to the situation at the moment. But this is simply to say that the Asian states from the very beginning, when they saw themselves as articulating a vision of the world, were concerned about Palestine in these types of circumstances. So that takes us, I suppose, to the present and the current situation in the existing tensions in Palestine. I don't really know how to approach this topic because I think we're all familiar with what has happened. With the Hamas attacks killing civilians, the atrocities that Hamas had committed, which are clearly war crimes. Killing civilians and taking hostages is a war crime. And then we come to the Israeli response, a response articulated as being in terms of self-defense. And we are familiar, I think, from UN reports and all the aid agencies that are monitoring the situation about how devastating the violence inflicted on the people of Palestine has been. More than 30,000 people killed, and many of them women and children. We are here at a university, but it is sobering to know that every single university in Palestine has been destroyed, and many academics have been killed. What is the future of a country without universities and academics? So these are the circumstances that we are confronted with. But even more telling, perhaps, is all the material that is available on YouTube and TikTok and everything else that all of us can get access to, showing those terribly cruel details of the way in which the IDF has gone about this whole process of dealing with the problem, as they see it, of Palestine in its and their pursuit of Hamas in these circumstances. And we also know that at this point of time, virtually all the United Nations organs have been involved in this process. The United Nations General Assembly has passed a resolution calling for the release of hostages, but also for a ceasefire. The Security Council has passed a resolution. The International Court of Justice is involved in this. And most recently, we have the International Criminal Court prosecutor requesting arrest warrants for both Israeli and Hamas leaders. So these are the circumstances that we find ourselves in. And it is something that should occupy us as international lawyers, but also perhaps in a much more profound way. No man is an island entire unto himself. And here, looking at this from an international law point of view, what interests me is this question of who makes international law in these circumstances. So I would make a very crude distinction. There are some wars, many of the wars in non-European countries, where the existing law is applied and developed. In other words, there's an existing body of law where certain of the content of that law, we apply that law, and there are new problems, of course, but these further extend the reach of the law. There is another category of wars, I would argue, which create the law. So it's a distinction between wars to which the law is applied and wars which somehow create law. And what do I mean by that? Well, let me take the war on terror. So here we had the United States saying we are acting in self-defense, again, against a non-European entity. But it was more than ISIS and Al-Qaeda, of course. It was the whole of Iraq, it was Afghanistan, and so forth. And in order to justify itself, the United States presented these new ideas of preemptive self-defense and the whole doctrine of unwilling and unable. And so the question that interests me as an international law and somebody who does not know much about international humanitarian law is, what will the impact of this law, of this war be, the war between Israel and Palestine? What will the impact of this war be on these fundamental principles of proportionality, on military objectives, of the very idea of the civilian? That is still, I think, undecided. We think we know the law, but all of us who've been trying to follow the ICJ and so forth realize all the complexities. And as a result of the latest provisional measures decision, we have arguments about the meaning of a comma. What does a comma suggest? So we can see these intricacies all going on. And then the question is, who is going to make the law, having asserted that there are these ambiguities, or having asserted that military objectives should prevail over everything else? And here, it's interesting to note that Israel's wars have had a profound effect on the making of international law, because we might note somebody saying, now you might remember that in the litigation between South Africa and Israel, and of course Israel took great exception to being charged with genocide, the South African lawyers introduced a statement made by Prime Minister Netanyahu about Amalek. And they cited that as evidence, Amalek, of a genocidal intent. Now, Israel, of course, took great exception to this. Now, here is somebody writing about Amalek in a much earlier text in terms of its importance as a precedent in the making of international law. He says, we read in Joshua 6:21 that the children of Israel killed the children in Jericho, and Saul slew the children and young women of Amalek, both on the authority and command of the Lord. Whatsoever things were written aforetime were written for our learning. Therefore it must still be true today that it is lawful to kill the innocent if the war is just. We go back to the idea of a just war. And it is permissible to kill the innocent. The passage I just read out about Amalek is from Francisco Vitoria, writing in 1530. So even from that time, we have a situation where these wars had an impact upon the fundamental formation of the ideas of international law. From 1530 to who knows when, we could say in these types of circumstances. Now, I should say that Vitoria himself said he disagrees with that principle, and he found another text in the Bible to justify his position. So it is in these circumstances that I also wonder whether what we might call a colonial war, what I have described as a colonial war, can be, in effect, a war conducted in the present, but shaped and justified through the modern language of the Geneva Conventions and ideas of proportionality and military objectives and so forth, in such a way where everything becomes a military objective, then it is permissible to take action against that. So here we go to another theme then, which is the theme of the ways in which colonial and imperial structures might be able to reproduce themselves in a language of modern international law, which sees imperialism as a thing of the past. And in fact, that language sees itself as being the counter to imperialism. And the question is, can it still be used to further imperial project? And what is international lawyers is the simple fact that certain states, certain powerful states, devote a great deal of effort and energy and also collaborate with academics, or academics collaborate with them to develop a particular vision of the law. And so this article is very interesting. It's called State Academic Lawmaking by David Hughes and Yali Sharensky, Harvard International Law Journal 2023. They focus on three countries. The United States when it comes to preemptive self-defense, China when it comes to the South China Sea, and Israel when it comes to international humanitarian law and the laws of war. And they discuss the way in which powerful states try to present a vision of the law that actually corresponds with what they are intent on pursuing. So I think this is something that all of us as international lawyers should at least be aware of, if not concerned about, because at the very least, we would want an international law that applies equally to everybody, rather than a situation in which an international law is refashioned by a powerful state to suit its own interests. So those are some of the themes that we might consider. And let me just conclude, because I've spent far too much time on already. Please excuse me. Where are we now in terms of this whole question of empire and imperialism? Well, we can think of it in a number of different ways. Now, some scholars have said that what we are thinking about is a shift from a unipolar moment to a multipolar moment. That is what is traumatizing the international system. But from the point of view of Asian states in Bandung, what they would say is both unipolar and multipolar are still versions of imperialism. In other words, you have imperial power. In one case, you've got one imperial power, the United States. Now, in a multipolar world, we might have multiple imperial powers. But as far as we're concerned, that is not the ethical or legal foundation of the system of law and world order that we should create, which should be in the interests of everybody. So that would be one theme we could think about in this respect. Another theme we might think about is, as a result of the litigation following the war that is taking place now, for the first time, I think in history perhaps, we have somebody who is supported by the West being potentially subject to an arrest warrant. And that is Prime Minister Netanyahu. And I think the Defense Minister Gallant. And in these circumstances, the interesting question is, has international law finally demonstrated that it could be used against the West? Or has international law always been a law that the West produces in order to ensure violation by non-Western states? Going back to Victoria, that's what happens, isn't it? You create a system of law that is supposed to be universal, but in fact only binds non-Western states in a way that those non-Western states inevitably violate that law, as a result of which you can engage in violence against them. You can engage in war. Now, where is Hamas in all this? So I think Hamas has committed war crimes. It's as simple as that. It has committed atrocities and should be held accountable. But I don't see a possibility of the less powerful states having the same advantages in trying to shape the law to suit them. I suppose that is the particular question that, the more specific question that I as a scholar of international law would try to suggest. Will there ever be a non-imperial world? Well, I think one of the features of this time is that people are becoming much more aware of this unequal structure than ever before. This is especially the case. We've always known it, I think, in Asia, right? We've always known it's unequal. But I think in the West, what we see are all these students and these young people saying, this is really basically messed up. I don't know what will follow from that, whether there'll be a significant change in the international order, but we can see how this theme has now raised the question in a very prominent, explicit way in every sphere, pretty much, of Western society. What will follow from that, I don't know. Will imperialism ever come to an end? I don't know. But what I am sure about is that even if imperialism never comes to an end, there will always be people fighting against it, however futile and absurd that fight might be. There is something about the human instinct for freedom that will lead to resistance and an ongoing struggle that will hopefully bring us global justice. Thank you so much. Sure. If I was talking about economics, I would have used that term. It's a very important term. I had some difficulty in deciding how to present something in 20 minutes. And it wasn't 20 minutes anyway. But if I had spoken more on economics, I would have made similar arguments about the way in which imperialism reproduces itself. And in fact, the leaders at Bandung, Sukarno, in his opening speech at Bandung said, we might succeed in winning our sovereignty, but that is just the beginning, because we now have to face the new forms of colonialism that are more economic in character and more subtle. Thanks. Yes, I do. And that's why I'm interested to see whether in these circumstances, what is going to be decided by these various tribunals and so forth. But it's also very heartening. I think the other thing that this crisis has demonstrated is just the sheer, what can we call it, all the problems with the current international system as far as, for example, the United Nations is concerned. So perhaps that will lead to another campaign yet again to reform the Security Council because it seems that the General Assembly has been much more sensible and active and humane in the way it has addressed that. So I'm not suggesting that we should give up on international law. I do think there are many parts of international law that need to be reformed. But at this point of time, at this desperate point of time, sometimes all that we're asking for is the fundamental principles of international law to be complied with by all states. We're not even thinking about, it's something like torture during the War on Terror, right? You think it's a fundamental principle. It's a jus cogens. Was it in the ILC Commission? Okay, torture. Yes. And then suddenly we find with 9/11 and the War on Terror, there's a complete redefinition of torture. So that's what I would call stage one, not even reform, just applying the existing international law equally. And unfortunately, the United States' response, threatening the ICC, for example, is a massive embarrassment because it suggests to the rest of the world that the rule of law is not taken seriously when it is to apply to our allies or to ourselves. And what more can be said? I mean, it is so blatant and stark. Thank you. So I think it also suggests that what's happening among many ordinary people in the West, ordinary decent people saying we can't just tolerate this. And in terms of making some of these themes explicit, it is quite extraordinary to read what some senior Israeli politicians and leaders say. It is extraordinary in terms of the dehumanization of the Palestinians and suggesting complete conquest in effect. But it's also fascinating to see, how all that is, the attempts that are being made to justify all this or overlook it. That is also fascinating. So we are in this, what can we call it, interesting time. It is an interesting time to be an international lawyer. And I'm so glad that we here at the Asian Society of International Law are able to meet and as scholars discuss these issues that are of great significance to our profession and to the world. So thank you very much again.
Thank you very much, Tony, for this, should I say, historical speech.